Sharath works as office manager, Cambridge Heating and Cooling Company. Her lovely daughter, Niranjana Nair, is studying in grade 11, and son Tejas in grade 7. I welcome Anju Nair to moderate this session. Over to you, Anju.
Thank you so much, Alan. Let us begin this beautiful morning with the land acknowledgement. We would like to begin our acknowledging that the land on which we gather is the traditional territory of the Vidad, the Anishinaabe, Haudenosaunee, Métis, and Mississauga of the Scugog, Hiawatha, and Alderville First Nation. Let me take this privilege to welcome our eminent guest speaker, Vrishani Vettivel. Vrishani Vettivel is the founder of Vettivel Law in 2016. Prior establishing her own practice, Vrishani obtained her Bachelor's of Business Administration from the University of Toronto with specialization in finance and strategic management. Then later, she moved to United Kingdom and obtained her Bachelor's of Law from City University of London. During her tenure in UK, Vrishani was a part of argumentative essay writing services of organizations, including the Free Representations Unit, where she provided legal advice, case interesting topics for presentation, and advocacy under the supervision of caseworkers pertaining to unfair dismissal and other employment litigation matters. Upon returning to Canada, Vrishani pursued her Master's of Law degree from Osgoode Hall Law School, also working simultaneously in the areas of personal injury and medical malpractice at various mediation centers. During this time, Vrishani worked at the Municipal Property Assessment Corporation, where she specialized in legislation, regulations, guidelines, and procedures relevant to municipal law, with specific reference to the Assessment Act, Municipal Act 2001, and City of Toronto Act 2006. Vrishani then pursued her articles with Marani Law, where she focused on residential real estate, refinance of mortgages, immigration law, corporate law, and wills and power of attorneys. Vrishani is a member of the Canadian Bar Association, the Ontario Bar Association, and the Law Society of Upper Canada. She is also a part-time lecturer at Home Life Future Reality Incorporation. Vrishani is licensed to practice law in the province of Ontario. On behalf of MASO, I welcome you, Vrishani, for this beautiful occasion. Please, over to you.
Hi, Anju. Thank you very much for that very lovely introduction. And hi, everyone. My name is Vrishani Vettivel. As Anju said, I am a licensed lawyer in Ontario, and I'm here to talk to you today about wills, power of attorneys, and how this ties into real estate law. I'd first like to thank the Maslow organization for asking me here today to speak on these important topics. And I'd also like to say that what your organization is doing for the community is absolutely amazing. And I'm honored to be here today to speak on these topics and to educate you all on the importance of wills, power of attorneys, and real estate. So today, this session is intended for all the community members here who wish to expand their knowledge on wills, power of attorneys, and real estate law. And by the end of this session, I'm hoping that all of you will have a clearer understanding of these concepts that govern wills and why we need them, and power of attorneys, and how all of this is integrated with real estate law. So throughout my session, if you feel that you have any questions or things you want to ask me, after the session, I'll be taking questions. So if you feel that you want to ask anything, just write it in the chat box. And after the session, I will be more than happy to answer them. So firstly, I'm going to be speaking about wills today. So a lot of you may wonder, what is a will? Why do we need it? What happens if you don't have one? So A will is a person's written document. So it's a legal document that a person drafts up that sets out their wishes about how their estate is going to be handled after they've passed away. So this takes effect after a person has passed away. And what they do with this will is they outline who they want to be what's called their estate trustees, who they want to be their beneficiaries, which are the people who will inherit their assets after they have passed away. And they'll also name what assets they have, etc., and what they want to put in this will. So firstly, what is an estate trustee? So an estate trustee is a person, either one person or multiple people, that you will name in your will to take care of all of your personal belongings or your financial assets after you've passed away. So this is essentially a person that you trust, and this person will take care of all of your affairs, including paying out your expenses, paying out your funeral expenses, paying out your debt, paying out anything else that you require. And the estate trustee will be the person who hands your assets over to your beneficiaries after you passed away. So the criteria for an estate trustee is they must be over the age of 18 years old and they must be mentally capable. So this will be the person, as I was saying, they calculate the total value of all the assets you have. So pretty much once you've passed away, what you will do is you will take a will that you've drafted to court, and then at that time, they'll ask you for all of your assets. So they'll ask you like to list all of your assets, and then at that time, you'll calculate everything you have, what it's worth, and then any debt that you have in your sole name, you will pay it out at that time. If you need to, you'll apply for probate, you'll pay out your expenses, and then after that, the estate trustee will take those assets and then they'll distribute the assets in accordance with whatever the will says, so whoever your beneficiaries are. If you don't have a will, so I get clients all the time that come to me and say, do I actually need a will? What's the importance of it? Why should I have it? So in the event that you don't have a will, this means that you've actually passed away without leaving any instructions as to how your property will be divided and distributed after that point. So if you've actually passed away and you haven't said anything, then the legislation known as the Succession Law Reform Act, this will actually govern how your property will be divided if you do not actually have a will in place. So if you do not have a will in place, what will happen is, since you actually haven't appointed an estate trustee, the courts will appoint someone on your behalf to act for you, and they will actually appoint their own estate trustee without a will. So they'll appoint their own person to be the estate trustee in this situation, and then they will be the ones to calculate everything that you have, all of your assets, whatever everything is worth. They'll of course take a fee out for themselves, and they'll distribute it in accordance with the Succession Law Reform Act. The legal requirements to have a will is the person who writes the will has to be the person who signs the will. So every person, so I often get this question, okay, can a family make one will on behalf of the entire family? So the answer is no to that. Every single person must have their own will, and whoever drafts their own will must be the person to sign their own will. So this must be signed by the person who's actually making the will, and this in legal terms is known as a testator. And it also must be witnessed by two people who do not benefit under the will. So when I mean by benefit under the will, if let's say a husband and wife gives all their assets to their children, and then they say in the event that something happens to the whole family, they'll give it to their siblings, then anybody who directly or indirectly benefits from that will cannot sign the will. And if they do, then the will not be valid, and the will can easily be challenged on that basis. So for example, if a husband and wife draft a will, then obviously the kids can't sign it, the siblings can't sign it, and anyone else who's related to the siblings won't be able to sign it either. The will, so as I was saying, what the will does is it sets out, first it appoints the trustee and the beneficiaries. So at the beginning of the will, you'll say that this is my last will and testament, and I appoint X person and Y person to be my trustees. So just so you all know, the trustees and the beneficiaries, if you want, can be the same person. So a lot of people will ask me, okay, let's say if I'm the husband, can I appoint my wife as the first trustee, let her pay out all of my debts and taxes, and then can she be the first beneficiary? And the answer is yes. So you can actually have your trustees and your beneficiaries be the same people. if you like, but sometimes some people may not always want that, because then they'll say, okay, if I think, like, if I'm a husband and I think, okay, my wife in that, if something happens to me, she may not be in the right state to ask these type of questions, or she may not be in the right state to like do all this paperwork because she'll be so distraught, then you can put somebody else, like a sibling or a brother or someone else, to be your trustees, and you can tell them, okay, you're the one that pays out all my expenses, and then after that, give everything to my wife. So what the trustees will do is they'll pay out all the debts, they'll pay out all the taxes. And keep in mind here, there's a lot of liability that can happen if the trustees don't do this job properly. So I get a lot of situations at my law firm where, like, if someone passed away the past year, they'll come to me the next year and they'll bring a notice from CIBC. So I got an example where someone brought me a letter from CIBC saying they had $40,000 owing in their credit card, and they were accusing them of fraud because they were saying, okay, this person passed away, they didn't pay out these debts. Now they're looking to the beneficiaries to pay out these debts. So then I told them, look, this could be just simple misunderstanding, go and like speak to them. And then, but it was just a whole legal hassle, right? So a lot of the time the trustee needs to do this part of the job properly and make sure if there are any debts in the sole name of the person who passed away, they're required to pay out these debts on the estate before they pass whatever is left over to the beneficiaries. Because when the beneficiaries get these assets in their hand, they don't want to have to then pay out more debt. So this part is very important, and the job of a trustee is also very important, as you guys can see. So after the trustee does this and they pay out the funeral expenses, any taxes they need to, and anything else, whatever is left over, they give the remaining assets to whoever else is listed in the will. So then at this point, if the person has listed their family members or whoever, then you will at this time give whatever's left over to them. And then in this way, the point of the will is that it's ensuring that whatever wishes you have and whatever specific requirements that you set out in the will have actually been met. In the event, so I was telling you guys that it's very important to have a will, because then by having a will, you can choose who you actually want to give all your assets and everything to. But a lot of people don't actually do a will. So if you don't actually do your will and you pass away, then what happens is there's a certain order of distribution under the Succession Law Reform Act. So under the legislation, let's say, for example, I'm going to use the example here of a husband, right? So if you have a spouse but no children, right? So if it's just husband and wife, your spouse will inherit everything. If you have a spouse and children, then your spouse will receive the first $200,000 of your assets, and everything left over will be divided. So for example, I'm going to use an example here where, let's say, for example, the family has $300,000 worth of assets, right? And it's a husband, wife, and 2 children. So let's say, for example, if anything is left over, so if you have only 1 child, your spouse and child will split the residue as 50-50. So this means that the wife will inherit the first $200,000. Then out of the remaining $100,000, the spouse will inherit $50,000. The child will inherit $50,000. If there is more than 1 child, your spouse will receive 1/3 of the residue, and the rest will be divided equally amongst all your children. So in this case, let's say there are 3 kids or 2 kids in this example, right? Then out of $300,000 worth of assets, the wife will get the first $200,000. Then you'll divide the last $100,000 by 3. So then the wife will receive $33,000, $33,333,000. The first child will receive $33,333,000, and then the second one will receive the same. So as you can see, the balance just gets equally divided after the spouse receives the first $200,000 worth of assets. If you have children but no spouse, so in the same example, if the husband doesn't have a wife but he has children, then the children will inherit an equal portion of the entire estate. If you have no spouse and no children, then, so if you have no spouse, no kids at all, your parents will inherit your entire estate. If you have no spouse, no children, no parents, your brothers and sisters will inherit your entire estate. And if you have no spouse, no kids, no parents or siblings, then your niece and nephews will inherit an equal portion of your estate. So as you can see here, the Succession Law Reform Act, it actually outlines the exact order of who gets what in the event that you don't have a will. And a lot of times people don't actually like this arrangement. They much prefer that if they do have a spouse, they prefer that their spouse inherit everything, and then the spouse makes a decision of how much they want to give their children, when they want to give it to their children, etc. But when you don't have a will, you're subject to this automatic order. And if this is not something that you want, then you should get a will, because a will is very important. And even if you don't have a will and you're okay with this order, it takes a lot longer. And the courts also appoint their own estate trustees in the situation, which means that a portion of the money you made actually goes to the court, because now they're the ones that are dividing your assets for you. So some frequently asked questions, right, that people always ask me is they'll come to my office when they're usually doing a real estate transaction, and they'll start asking me about wills. And then they'll ask me, should the will be signed in front of a lawyer? So the answer to this question is there's no actual legal requirement that the will needs to be signed in the presence of a lawyer, but it is beneficial, because if the will, so as long as I was saying before, the only requirements to actually have a will is that it needs to be signed by the person who writes the will, and it needs to be witnessed by 2 people. But what happens is when you don't sign it with legal advice or legal guidelines, then it doesn't, if it doesn't conform to the legal guidelines of your particular state or your particular region, then it's not going to be recognized. So for example, if you don't know that you're supposed to sign it with witnesses and you type out a will and you hand sign it, then the will is not going to be valid. So once again, a will has to be signed in front of a person making it, as well as 2 witnesses who do not benefit under the will. Because if you sign with the person who benefits under the will, then once again, the will won't be valid. But usually when you have legal advice or when you've gone to an expert about it, there's a number of other clauses that we can put, and we can do estate planning for you, and we can insert other clauses into the will that ensure that all of your actual wishes are fulfilled and that the will doesn't get challenged. What I tend to find is that when a lot of people do this without legal advice, they don't know what legal clauses actually need to go in the will, and they don't know how it best protects them. So what ends up happening here is that you increase the chances that the will actually gets challenged once the person passes away. And the last thing you want in those type of situations is to have your will actually being challenged by people. So it's one of the things that is beneficial to have it, but it's not legally required to sign in front of a lawyer. And there are actual additional issues. So a lot of people don't know that. They just think, okay, I'm just going to write a will. I'm just going to put everything to my kids. I'm just going to sign it. And they don't know that they have to think about anything else. But there are other issues that you have to think about. So for example, you may want to put specific wishes, such as funeral wishes or organ donation wishes or anything else like that. And also, a lot of people don't realize that there's a tax payable as well when you certify the will. So what this means is that when a person passes away, what they do is they take that will to court. So until the time that a person passes away, a will is just a legal document that you sign with 2 witnesses and you keep with you. In Ontario, we don't actually register the wills anywhere, so it's just a document that you keep with you. And then after the point where a person, let's say, passes away, then you take that will to court. And the process of the court calculating your assets and what's called certifying your will, this is known as the process of probate. So at that time, depending on what you have, there's a detailed calculation of what's excluded, what's included, and then you pay tax on that. So a lot of people try to avoid this particular part of the process, or they try to reduce the amount of tax payable. So usually if you talk to a lawyer with regards to this, then you can also find ways to reduce. So I'm going to talk about this a little bit more when I talk into the real estate portion of this, but usually people can try to reduce the amount of tax payable by putting their house jointly, things like that. But these are also things you won't know unless you go to a lawyer and ask them, look, what do I need to do if I want to get a will? What are things that I need to think about? And something else that a lot of people ask me, they actually ask me if holographic wills are legally valid. A holographic will, for those of you who don't know, is a will that is handwritten by a person and then signed by that person. So a lot of people, what happens is, let's say if somebody's on their hospital bed and they're in an end-of-life situation and they say, okay, I never made a will, but I want everything to go to my kids, and specifically I want like particular jewelry to go to this child, or they have certain requirements that they want, so they take out a piece of paper and they write it. So Holographic wills are actually valid. And holographic wills are exempt from the legal rule that they must be signed in front of two witnesses. So keep this in mind. So if you actually take out a piece of paper and you handwrite your will and then you sign it by yourself, it is actually legally valid. But keep in mind, it has to obviously conform to other legal guidelines, otherwise it won't be recognized. So obviously don't make any spelling mistakes in the names and other legal rules. But a holographic will is, once again, a will that is handwritten by somebody and then signed by them. And then that will is valid. But if you type out a will and then you sign it yourself, that is not valid. So it's important to keep that distinction in mind. Another question that I always get is the last will and testament valid globally? What this means is that, let's say you write a will in Ontario. There's a lot of people, my clients all the time, they always say, okay, I've got property here in Canada. I've also got property in India, or I've got property in Sri Lanka, or I've got property in Malaysia. So can I use this will for my property there? So the answer to this specific question actually lies with which country you have your specific assets in. So I'm going to give you guys a short history lesson here. So the concept of international wills is governed by the Uniform International Wills Act. So back in the day, so it's very common now with migration and the increase in globalization and everything of that nature for people to be living in different countries and to have properties in different countries. And a lot of people these days are studying abroad and buying property abroad, etc. So back in 1973, several countries together, they formed what was called the Convention Providing a Uniform Law on the Form of International Wills. What this meant was that if your particular country signed this convention back in 1973, then your will would be respected in any country that was a part of that treaty. If your country was a part of this convention, then your will would be honored in that particular country. But if your specific country was not a party to the wills, then it could still be accepted if it conformed with the local laws. So what this means is, let's say, for example, I'm going to use the example of the United States. So since the United States is part of that particular, is part of the convention. So let's say, for example, you write a will here in Canada, but you have property located in the States. If you take your will that you made here in Ontario and you go to the States, chances are, since they're part of this convention, you have to attach the back of your will. So you'll write your will, then you'll write a page. It's a one-page document called the Certificate of International Will. And it says that this will is legally valid in any other country that is a party to this convention. So if you take this will to the States and they see that you have a will and behind your will you have what's called the Certificate of International Will, then they'll be able to honor it. So you won't need to rewrite your will in that particular country and you'll still be able to use it. But the big problem here is that there's not too many countries that are actually a part of this treaty. So a lot of the first world countries, so like Canada, the United States, the UK, a lot of them are part of this convention, but a lot of people don't actually know which country is part of this convention. And the countries like India, Sri Lanka, Malaysia, those countries are actually not a part of this convention. So what happens is if your country is not part of this convention and you write a will, let's say in Canada, and then something happens to you and you take the will to, let's say, India, then if it's not part of the convention, what they will do is they'll still look at the will and they'll see if the contents of the will and the legal jargon and everything else in there conforms with the laws of their country. If it does conform with the laws of their country, then they will allow it. If it doesn't, then they will not allow it. So my specific recommendation when people come and ask me this is I always recommend that you just have a specific will governing your assets in your own country. So if you have a will in, let's say, Canada, you keep one there, but then you also get a will drafted in India, in Sri Lanka, and Malaysia, wherever you have property located in. So you can just call any lawyer or legal expert in that particular country and tell them to draft a will for you and they can send it and you can sign using your original signature, get witnesses to sign it, etc. So you can complete the process, whatever the specific legal requirements of the wills are in that country, whether it needs to be notarized, etc. You can talk to whoever is an expert in that country, see what the requirements are in that specific country and do it that way. But usually these are always the choices. So you can either attach a certificate of international will to the back of your will, and then if something happens to you, show it to that particular country. But if the country is not a party to the Uniform International Wills Act and they didn't sign this convention back in 1973, then you decrease your chances of it being recognized. And then you have to see if it conforms to the local laws. So this is why I always suggest it's just better to have separate wills for each country that you have property in. But if you don't, then these are the other options for you. Another question I always get is, can the last will and testament be compatible with certain cultural needs? And the answer to this is yes. This is also why it's important to get a legal advisor or a lawyer or someone to do the will for you, because then we can incorporate these specific wishes into your will. So the first example includes funeral wishes. So I always get clients that come and ask me, okay, I know like my trustee and my beneficiaries, they'll do the funeral the way I want, but I have these specific wishes, and in that time they might be stressed and they may not include it. Can you include these wishes into the will? So the answer is yes. So some examples of this are, let's say for example, a client who is Hindu, they want to make sure that their funeral is conducted in accordance with the Hindu wishes and values. So I can say yes, and then in the will, I will insert that. I actually had a client who came, and they were from the Philippines, and they told me that what they wanted to do was they wanted to insert a clause into the will where they said that once the family received their ashes, they actually wanted the family to travel to the Philippines, and under running water, they wanted the family to pour the ashes into the running water, and that's how they felt that they wanted to depart from the world. So I told them, yes, of course, like this is your wish, and I can definitely put it in the will. So whoever is executing this will on behalf of you, they will be able to honor this wish for you. But these are the types of examples that a lot of people have, and a lot of people, other people will usually ask me, like, can't I just tell my family to do this? The answer is yes, but there are some people that want it done to such an extent, and they want to ensure that this wish is fulfilled, and it gives them the peace of mind knowing that if it's in their will, then when it's at the time that someone passes away, they can just look at the will and they can execute according to those wishes. Another example includes organ donations. So if you want to donate your organs, what you can do is, outside of your will, of course, you can register with a hospital or any other body, but sometimes people want to also put it in their will and say that in case I pass away, I want my organs donated to such and such organization or XY hospital. So I'll say, of course, if that's something you want, then I'll put it in your will, right? And I'll also advise them, like, let your local hospital know, things like that. So another example here is, I actually had a client who his daughter was actually a doctor, and she studied from U of T. So he told me, look, when I pass away, I want to give my organs specifically to the U of T Research Center, because I want them to benefit, because, they helped my daughter study through medical school, and now she's a doctor because of them. So this is what I really want. So I said, of course. And he said, I want it to be that specific U of T medical facility. So I said, of course. So we did that. And then we also helped him get in contact with them and sign their registration forms as well with the university, as well as we put it in the will. But these are things that people are often thinking about that they'll want to do. So I'm always happy to help out, but these are also things that they want to put in their will. And if you want to do that, then you should know that you do have the option of including that in. Another one is the Islamic Sharia law. So sometimes I get clients of like Muslim faith or Islamic faith, and then they'll say to me, I come from a country where we have like multiple wives, and I want to incorporate that into my will. So if you want to do that, then you usually have to find specific lawyers that are competent with the Sharia law provisions, and if they are, then they can definitely incorporate a lot of these rules into your will so that you're not exempt from some of the general rules that govern Ontario law. So usually what we would do here is we would have to specifically, we wouldn't say if something happens to your husband, everything goes to your wife. We may outline it a little more specifically, and we may say like this person gets X share, this person gets Y share, this person gets Z share. So usually we can do that. The will can be tailored in accordance to your wishes if you have certain cultural needs or specific wishes that you want. Another question that I often get from people is, what happens if you actually get divorced, right? So there's a lot of couples, they come in, the husband and wife come in, they both do their wills together. Of course, as I was telling you guys, every person is their own person. So there's not one will for a husband and a wife, or like however what your marriage arrangement is, right? every will is for their own person. So if you get divorced, of course, you can just make your new will. So what happens is every single time we make a will, the very first sentence on the will is a will can be revoked by making a new will. So we'll say we hereby confirm that any previous will or power of attorney drafted hereby before me is now revoked. So if you, let's say, get divorced and you say, no, I do not want my wife to have anything, I don't want her to have a penny, whatever you want, we can definitely make a new will, and you could re-sign a new will saying that when you pass away, it goes to whoever you now want. And anybody can do this for you. You can do this yourself. You can get a lawyer to do this for you. And a lot of people also ask me, okay, 10 years ago when me and my wife were on good terms, we went to this lawyer and together we drafted it with this lawyer. Do we have to go back to the same lawyer? I don't want to tell him I'm having marriage issues, this and that. So then no, anybody can make the will for you. So any new lawyer that you want to retain, you can use and they can make a new will for you. So you don't need to actually worry about that. And another question that I often get, so I get sometimes clients who have children with disabilities, or they want to ensure that a certain portion of the money gets used for specifically the purpose of education, etc. So what happens if you, like, let's say, for example, you have children that are about to go to university and you don't trust them to inherit everything. You think they're going to spend it, but you want to make sure that they use a certain amount of money is being given to them every year that they use specifically for education, or if they're disabled, specifically for disability funds. What you can do is in your will, you can authorize your trustee to set up a trust. So what they will do is you'll instruct your trustee, okay, let's say, for example, your kids are 17 and they're going to university next year, right? You can say, okay, you don't want to give everything to your two children or your child once they become 18 because you still feel that they're too young and they're not responsible enough to handle it. What you can do is you can tell the trustee, okay, don't release everything until they're older, but for the purpose of the will, when in case anything happens to, like, let's say the mom and dad, then the trustee will give, let's say, for example, $10,000 a year to the child each year that they use specifically for the purpose of education. So the parents can actually control that, and they can set up a separate trust fund for the child during the time that they're in university, and the money can be used for the purpose of education. And this way you ensure that they don't go spend all their money gambling or whatever else you may not trust your child to do. But you can definitely do that. You can set up a trust and you can give money specifically for the purpose of education. Similarly with disability. So if parents are worried that their child is disabled and they'll need someone to, like, pay for certain disability funds, they can also authorize their trustee to do this for them. And they can say, every year, I want you to give money to my child so that, like, you can pay for this particular disability, or you can pay this particular center that is helping my child with this or that. So you can do that, and you would do that by way of trust, a trust fund. But once again, the person you choose as your trustee has to be a very trustworthy person, because they're the person that you're appointing to do this for your beneficiaries, your underage kids, etc. Another question that I very commonly receive is, what happens if both spouses pass away and the children are under 18? It's often a very common question with parents because they're scared. Like, so what happens if, because you never know what's going to happen in life. So this situation is also why it's especially important to actually have a will. So if you have a will, right, what you can do is you can appoint what's called a temporary guardian. So you can say, like, okay, in case the mom and dad both pass away, then you can appoint, like, one of your siblings or someone you truly trust to be a temporary guardian. So in order to become a permanent guardian, that's not through the process of the will. You have to apply to court separately for permanent guardianship. And even you have to apply to court for the temporary guardianship as well. But at least in your will, you could show the court, like, look, the parents wanted me to be the temporary guardian, and the court will almost always grant it. And then after that point, temporary guardianship gives you 90 days. Then you can go back to the court and you can ask them for permanent guardianship. So usually if you have a will, it's not such a tedious process. You can just appoint a temporary guardian for your child, and then after that you can go and appoint a permanent guardian. But if you do not have a will and your kids are under the age of 18, then what happens is their money is held in a trust. So if the mom and dad pass away, the kids can't access the money. Their money is held in a trust, and it's managed by a trust administrator or an executor of your child's guardian until they reach the age of majority. And this is handled by the courts. So the trust administrator will be the trust administrator will be a person who is appointed by the courts, and the executor as well. Or if a person has separately applied. So what would have to happen is then, like, let's say parents pass away and the siblings are like, oh my God, the parents did not have a will. Then they'll go to court and they will try to apply to be a child's guardian right away. But then the big issue here is that there may be so many people that contest, and the courts don't know who the parents actually preferred. So you get into a situation where the courts actually have to appoint the guardian, and then if they've appointed the guardian, then the guardian will hold the money in trust. Otherwise, it'll be held by a trust administrator until they reach the age of majority. So when it comes to not having a will, when they say age of majority is 18. So once they reach the age of 18, they will give the money to the children. But a lot of parents don't always feel comfortable with the children having all that money at age 18. A lot of parents prefer like 22, 23, or 25. So that's also why it's important to have a will as well, because you can put that in your will and you can say, okay, if we both pass away, my mom and my children are underage, we'll appoint a child guardian who will release the money to my children when they reach the age of, let's say, 22 or 25, or upon completion of a university or college degree. Whatever you wish to put in your will, you can put that. But if you don't have it, then without a will, they'll get it once they reach 18 years of age. So these are a lot of very specific points that people often ask me about, and I hope the takeaway point for all of you when it comes to wills is it is very important to have a will. It's relatively inexpensive, but it saves you lots of trouble and headache once you pass away. The last thing you want to think about is you get sick, you're in the hospital, and you say, oh my gosh, I did not write a will, I did not determine who gets my assets, and you don't want to be thinking about that. So while you're still healthy and able and capable of making a will and determining who gets your assets and who gets what, it's very important to have a will, and they're not expensive at all. So I recommend just get a will and just keep it and let whoever your trustees are know that you have one. And in case anything happens to you, then you'll be able to trust that they'll be able to handle it for you. The next concept I want to talk about is power of attorneys. So power of attorneys are similar to wills, but unlike wills, so wills are what happens after you pass away. A power of attorney is a legal document that gives someone authority to act while you're still alive. So if you think about it, power of attorneys are while you're still alive, and wills are for after you've passed away. So once again, a power of attorney is a legal document that gives one person the authority to act for another. So unless you restrict their powers, they can do almost anything for you except for make your will or write a new power of attorney. So some of the legal requirements and restrictions to be a power of attorney, they're the same as those for a will. You have to be over the 18 years of age, you have to be mentally competent, and you have to sign in the presence of 2 independent witnesses. So you have to be mentally competent in order to be a power of attorney. So you can't be mentally incompetent and then handle all the affairs for someone else. So you have to be able to give this power of attorney, and it has to be signed in front of 2 independent witnesses. So there's different types of power of attorneys. So the first type of power of attorney is the power of attorney for property. So the power of attorney for property is a type of power of attorney where this person has the power to manage all of your property, your assets, etc. Right? So this deals with anything else other than your medical health. So this is regarding your houses, your assets, your bank accounts, anything that's financially based. And usually there's 2 types of power of attorneys in this situation. You have a general power of attorney, which means that you're giving them all power. So all power over your financial assets, your financial management. And usually this is the power of attorney you'll take to the bank. So let's say if a person gives another person power of attorney to manage all of their assets and all their bank accounts, etc., the other person will take this power of attorney to the bank, and then they'll say, look, I have power of attorney over this person, like, can I withdraw X, Y amount of money, etc., right? So the difference between a general and a continuing is general power of attorneys are effective while a person is still mentally capable. But if they give what's called a continuing power of attorney for property to somebody, this means that obviously they have to make the power of attorney while they're still mentally capable. But in the event they become mentally incapable subsequently, then the power of attorney is still effective. So let's say, for example, if right now person X is very healthy, they give power of attorney to their spouse, right? So let's say a wife is in this condition, she's healthy and everything, they give power of attorney to her husband. And then after she becomes mentally incapable, she gave a continuing power of attorney, he can still continue to act if it's a continuing power of attorney, but if it's a general power of attorney, then he can't. So it's not effective once they become mentally incapable. But most people who give broad power of attorneys usually do it as a continuing power of attorney, so it's still effective. a limited power of attorney for property, what this is it's similar to the same power of attorney, but it's more limited in scope. So let's say, for example, you're going on vacation for 6 months and you want to sell your house, but you're not going to be here. You're going to be in India for 6 months. Then you can give power of attorney to somebody else for the sole purpose of selling that particular home. So you can say, okay, I give full power of attorney in relation to this property. You can sign anything for me for this house. You can sell for me. You can choose your own buyer. You can close a deal. You can sign all your closing documents. You have complete power over this specific house only. But the second that this house closes, your power of attorney is void, and it's only for that purpose. So you can give limited power of attorneys as well. And a lot of people do this in order to ensure that like they don't have access to all their bank accounts and everything, but they still want to give power of attorney to this. So limited power of attorneys are also very common. Another example is people who buy investment properties and they want them to just manage the investment properties, but they don't want them to sell those investment properties. Then you can also give a limited power of attorney, and you can say, okay, I give you full power to do everything with this property. You can find your own tenants, you can collect my rent, you can do et cetera, but you cannot sell. So usually it's whatever you put, whatever restrictions you want to put in your limited power of attorney, you can do it. And these are usually meant for a specific purpose related to property or financial assets. Another type of power of attorney is the power of attorney for personal care. So this is completely separate from the power of attorney for property. The power of attorney for personal care is governing your medical health. So a power of attorney for personal care is a written document that gives someone the power to make decisions about your personal care should you become unable to make these decisions yourself. So things that are usually captured in the power of attorney for personal care is end-of-life decisions, medical treatment, nursing home, etc. So for example, let's say, for example, a person is, they want to say, okay, like in case if they're getting older or if they get an accident, right? And they say, okay, I want to appoint this person, either my spouse or my parents or someone, to make all of these decisions for me. Then you would appoint the power of attorney for personal care. And these are so important, especially in the, for like hospital workers and for like the hospital centers and nursing homes and things like that, because when people, as they get older or if they get sick suddenly, they don't have the mental capability to make these decisions. So if they have somebody else to take care of these decisions for them, it becomes really important for them. So what a lot of people put in their power of attorneys is, let's say, for example, they're in the end of life stage, right? They're in a vegetable state and the only thing keeping them alive is machines and things like that. You can put in your power of attorney that your power, like you can put your wish in your power of attorney. So you can say, like, if you're in that state and you want the hospital to pull the plug on you, right? And you say, like, you know, if I'm in that state and nothing is keeping me alive and the hospitals have determined it, then you can put in your power of attorney that you wish for them to just pull the plug at that point. But usually if you don't write anything, then the person, if you can appoint someone to be your power of attorney for personal care, but if you don't write that, then usually that person will be able to make the decision. So usually when clients come to me and they say, okay, I want to make a power of attorney for personal care, I'll tell them, okay, and I'll explain to them that what this is, it's a written document that gives someone to make the power, to give somebody the power to make decisions for you, but you can put restrictions in your power of attorney. So if you have specific wishes that you're worried that your family may not execute for you when you reach a certain state, then you can put in your power of attorney certain wishes that you want fulfilled for you. And the person who you appoint has to fulfill your wishes, just like a will, right? So if you put in your power of attorney for personal care that if you are in that vegetative state and you want them to pull the plug on you, then they have to follow that and the hospital will follow that. But you can also put in your power of attorney that you want that person to make the decision for you, like you trust them completely and you want them to be able to make that decision, then you can allow them to do that. Same with any medical treatment, nursing homes, etc. So if you want around the care at your house, you can put that into your power of attorney, or if you want to just give that power for your power of attorney to decide completely for you, then that's something that you can definitely do as well. In the power of attorney, there's certain specific wordings that people always get confused about because they don't understand the legal jargon behind it. So they always ask me, what do these things mean? So when you're appointing a power of attorney, you can appoint someone. So if you want to appoint multiple people, so let's say for like a parent and you want to appoint power of attorney to your 2 kids, right? You can appoint them jointly, or you can appoint them jointly and severally. So what this means is that if you appoint a person jointly, if you appoint 2 or more attorneys jointly, everything that they do, they have to agree on. So whatever they are doing, they have to both agree, they have to both sign, they have to both be present, they must do everything together at all times. Jointly and severally means that they can make decisions jointly and separately. So let's say, for example, if a parent is appointing their 2 children to be their power of attorneys, whether it's for property or for personal care, if they appoint them jointly and severally, if one is not there, let's say one goes to vacation, the other can just make the decision for them and they don't have to worry. But if they are appointed jointly, then they both have to be present all the time. They both have to agree. And what parents do in this situation is always totally different. There's a lot of parents that want both kids at all times to agree on everything, because otherwise they won't, like, so for example, with power of attorney for property, if the parent has given their children power of attorney for property, they'll say, look, both of you, if you guys want to sell this house, you both have to agree together and do it. If one of you agrees and one of you don't, then I don't want you to do this. So that's often the common practice, but it really depends on the parent. And a substitute attorney is where you appoint one person or you appoint a couple of people. And if they cannot act and none of them cannot act, then the other person will be the power of attorney. So let's say, for example, if a parent, right, they have 2 children, they're quite different in age, maybe like a 9-year age gap, they'll probably appoint the first child to be the first power of attorney. And in the event that that first child cannot act as the power of attorney, then they'll appoint the second person. So that's known as a substitute attorney. If one cannot act, then they'll appoint the other person. And once again, does a power of attorney need to be signed in the presence of a lawyer? So the legal requirement is it needs to be in writing. So just like wills, it needs to be in writing and it must be signed in the presence of the person who is signing the power of attorney in 2 witnesses. But it does not have to be signed by a lawyer, but it's always recommended to be signed by a lawyer, especially with power of attorneys, because there's a lot of legal clauses that we insert in there and there's a lot of things that people don't think about, even like providing compensation to the power of attorney people. Some people will provide compensation. Some people will say, like, they don't need to take any money for this. They're doing it for family, etc. Right? So there's a lot of different things to be thought about. And you don't have to do it in front of a lawyer, but it's usually beneficial to get legal advice and to do it with a lawyer because you won't miss any legal clauses. But the legal requirements are it has to be in writing and it has to be signed in the presence of 2 witnesses. And once you've signed the power of attorney, a lot of people get worried that, okay, they've given power to somebody, but now they want to take it away. Like, what do they do? So you can put clauses in your power of attorney about how they're going to be revoked. So for example, let's say you're going on vacation for 6 months, right? You can put in your power of attorney that the power of attorney will automatically be revoked once you return back to Canada. So once you land in Canada, then the power of attorney is automatically revoked. So you can definitely do that. You can also put, like, let's say you've given a limited power of attorney to sell the property. You could say upon closing of this transaction, this power of attorney is null and void and no longer effective. You can do that as well. Or you can say this power of attorney is effective until such time that it's been put in writing that the power of attorney is revoked. Then that way you just send a legal notice or a letter saying that you can no longer act on the power of attorney, and then it ceases to exist. So I hope with wills and power of attorneys, you guys have understood the concept of both the wills and both the power of attorneys, and you can see how similar they are from each other, but as well as how different they are. So once again, power of attorneys are while a person is still alive and they're giving power of attorney to another person. Wills are after they passed away. So a lot of people, they'll come and ask me, how do wills, how do power of attorneys, how do these tie into real estate law? Like, how does this relate to me buying a house, or do I need to even think about this when I'm buying property? So a lot of people, what they do is they go and buy property, but they never think about these things. So they say, okay, I want to buy a house, and they go, but they don't actually think about the later, the future, etc. So the main part where this actually ties into real estate law is when a person buys a property, then they can take ownership in different ways. So if one person is taking a property, so if one person is purchasing a property, they will just own it as a registered owner. But if 2 or more people are taking property, they can take it as joint tenants, or they can take it as tenants in common. So what that means is joint tenants is a person who holds property jointly with another person. So if you hold a property together as joint tenants, let's say like a husband and wife buy a property together and they take it as joint tenants, both of them own 100% of the property together. And the important part is what happens with joint tenants is the right of survivorship exists. So the right of survivorship means that in case that person passes away, right? So in case they're no longer with us, the property, even if you do not have a will, the property will pass on to the other person jointly. So if you have a house in both names and one person passes away, that house will not be included in your asset calculation, which is also very important when I was talking towards the beginning of the seminar about probate taxes and things like that. So if the house is owned jointly, then you avoid that entire thing because this particular asset is in joint names. So it's not actually included in the asset calculation. So in this situation, all the client has to do is come to me and say, look, my spouse has passed away, and then I will check. It doesn't have to be spouses, but I'm just using the example of spouses here. So in that case, I will check to see how they took title. And if they took title as joint tenants, I'll tell them, don't worry, I can just register what's called an application of survivorship, and we can just transfer the property to you. And it's usually a very easy process if they both own property together. But if they've owned property as tenants in common, so what this means is 2 or more people, they share ownership rights in the property according to their percentage interest. So usually people who are like, let's say 3 investors, right? 3 friends, 3 investors, they want to buy a property together, but they want to say like, in case anything happens to me, my portion goes to my family. They don't want it to go to their other investors. So when people purchase property this way, then they'll purchase it as what's called tenants in common. So if 2 or more people, let's say it's 3 investors once again, and they take ownership as 33% for 33, right? Then what happens is in case one of them passes away, they haven't determined. So this is where it becomes really important to have the will, because here you're not giving it automatically to the other people, but you're saying like you want to tell like you want to say what happens in case something happens to that person. So in that case, then you will have a will. Then you should have a will, because the will will say, okay, in case I pass away, my portion of my assets go to this person. So when they calculate your asset calculation, this will be included. This house will be included in your asset calculation, and you'll have a 33% ownership in this house. So do you see there's a big difference here between the joint tenants and the tenants in common? Once again, the joint tenants is when you hold ownership jointly, and the house itself will not be included in the asset calculation because it will automatically pass over to the other person. And even if you don't have a will, you can do this, right? But of course, you should still have a will, because this situation doesn't answer the question. If something happens to all people on title, who does it go? And then that's when you're going to need the will. But for this purpose here, your joint tenants, it'll be an automatic right of survivorship. In tenants in common, it will not be. So your particular percentage, you have to indicate in some other document how you're going to pass over the asset in the event they do pass away. I sort of went over this particular question earlier in my seminar, but how is power of attorneys utilized in home purchases? So as I was telling you guys before, if you guys recall from my discussion earlier, when you have a limited power of attorney, you can authorize another person to sell, purchase, or refinance your home. So you don't have to use a limited power of attorney. You can still use a general power of attorney. So a general power of attorney will also cover this because it covers everything. But what you can do is you can use power of attorneys for home purchases. So if you want to buy a property or sell a property, you can authorize the other person to do this for you. Keep in mind that it's usually easier for real estate purposes. It's easier to do this when you're selling a home rather than purchasing a home, because when you're purchasing a home, you have to also deal with the banks in terms of power of attorneys, and that's a whole separate thing for another seminar, but that usually there's other restrictions involved in that, right? But for general purposes here, you can use a power of attorney and authorize another person to sell, purchase, or refinance your home. So I'm going to very briefly talk about, because the next part of this are all very broad topics. So I'm going to be very quick with these topics. And if you guys have further questions, I'm happy to answer these. What is the process of home ownership in Ontario? For those of you who are wondering about, like, you just come to Canada and you are thinking about buying a home and you don't know how to go about this, the very first point of contact for you will actually be a real estate agent. So since I'm a lawyer, I'm actually the last point of contact in this home buying process. But usually if you're thinking about this, you'll look for a real estate agent first. This person, in the most broadest of terms, will help you find a house, right? based on your income, based on your location, based on what it is you're looking for when purchasing a home. After that point, you'll either speak to a mortgage broker or a bank or a financial institution about how you're going to secure financing for that place. So in the event that you want to get it from first bank, a second bank. So usually the real estate agents, the mortgage brokers will work together to ensure that you are able to obtain a mortgage on your property if you need additional financing from the bank. And the final process, once you actually found your home, you've signed what's called an agreement of purchase and sale, which is an agreement to actually purchase a home in Ontario. So in Ontario, we use what's called the ORIA real estate form. And from that, what we do is you will have the sellers, you'll have the buyers, you'll have all the terms and conditions of the particular house you want to buy. And at that point, the lawyers start to get involved. So once you've done all of that, then you go to the lawyer, and then we pretty much just take it from there. So in summary, when it comes to the lawyer, our role in the home buying, selling process is once you've actually received your agreement of purchase and sale, and you've satisfied all your conditions in terms of being able to obtain financing, etc., then you can give it to a lawyer to review the agreement. So if you're actually buying a condo, usually what happens is one of the terms in there is you may have a status certificate from the condominium that you may want reviewed, just to make sure that the condominium is sufficient for your financial goals and it's a place that you want to live. So usually I'll review the status certificate for these. And if you're buying a house from a builder and you receive an agreement of purchase and sale from them, usually I can review that agreement as well to just make sure that there's no hidden clauses in the contract, and if there are, we can request that some of these be amended, etc. So usually what happens is, in short, once I review this agreement of purchase and sale, then I will opt to do the title searches on the property. So I will check the ownership of the property, and I'll make sure that there's no liens, no encumbrances, no issues. So what this means is that I'll make sure that there's not debts or other things on the house that prevent you from taking ownership. For example, there's no substantial restrictions. So let's say, for example, if you have a residential property and you plan to tear it down and build a commercial plaza or something like that with the property, I'll have to make sure that you are in your correct zoning and that there's no title issues that affect your ability to do this. And I'll also make sure that how you're taking ownership of the property. So once again, we'll go back into the joint tenancy versus tenancy in common issue here, right? And then I'll talk to you about the manner of taking title, and I'll also run the title searches, just make sure there's no liens or other problems with it. Afterwards, once you have actually gotten instructed by the bank, so the financing aspect of all this is completed and you have actually gotten instructions, and then now you want to actually close your house, at that time, I'll talk to you about things that are payable when you actually close your house. So I can go into a lot of these topics are a seminar of their own, so I'm just going to be really quick here, right? So when you actually do your closing, you have to pay a tax to the government. So that would be the land transfer tax that's payable on each house that you purchase. You'll have to order insurance to protect your legal ownership over the property. And some other fees that you'll have to pay for at that time are government registration fees, title search fees, legal fees, etc. So usually what will happen is around that point, I'll sit down and I will let you guys know, okay, these are your actual closing costs that are involved. Because a lot of times, you just come to Canada and you want to buy a house and you don't actually know what's involved. You don't know how much you have to pay. You don't know what you're looking for. You don't know any of these things, right? So it's always important to know, okay, when you do buy a house here in Ontario, you do pay a tax to the government. And if you are buying a house in Toronto, you actually pay two taxes to the government. You pay a land transfer tax to the province of Ontario, and you pay a land transfer tax to the city of Toronto. So usually the rate at which you pay is a percentage, and usually that percentage changes over the years. So it's always important to check and make sure you know exactly what you're getting into, and you can calculate your costs exactly how they are. And you also calculated some of your closing costs as well, so that you're well prepared for the home buying process. So once again, with home ownership, right, when it comes to buying houses and tying it into wills and power of attorneys that we've been discussing, if you pass away, and so if you pass away and you have assets, so let's say you have assets here in Canada, you have assets elsewhere, how does the home buying process and how does your house itself, what happens when you actually pass away? So I was telling you guys about this earlier. It really depends on how you took ownership over the house. So if you took ownership as joint tenants or tenants in common. So if you took ownership as joint tenants, right? So let's say in the example, once again, where a husband and wife have bought a house together, and let's say it's the husband who passes away, then for the purposes of wills and home ownership, you don't actually have to worry much. If you took it as joint tenants, we can just transfer the property to the wife's name if you took it jointly, because within the provisions, the right of survivorship exists. So you can actually transfer the property over to your spouse. So a lawyer will be able to do that, and you don't need to go through the courts for that. So you could just come to me and you could say, look, my spouse passed away, and then I'll say, okay, no problem. You have to, if you have a mortgage on the property, I'll tell you, okay, you have to notify the banks about this, that you actually, your husband passed away, and they have to update the mortgage papers appropriately. At that time, the banks may tell you, okay, they can just update it, or they may tell you, okay, we may have to redo the mortgage in just your name. So whatever the banks tell you is separate. For my purposes, if you've taken it as joint tenants, then what happens is, even if you do not have a will, I won't even ask you if you have one. If it's between husband and wife, and let's say the wife is the one that comes to me, then what will happen is I will be able to automatically transfer it by registering what's called an application for survivorship, and I'll be able to transfer it into the wife's name. The question when it comes to joint tenants is only in case something happens to all people on title. So let's say husband and wife took title together as joint tenants, then if something happened to both of them, because you never know what will happen in life, right? Then I'll ask you, okay, do you have a will, right? And at that point, the house becomes included in the asset calculation, and then they have to transfer to the children. If you bought the property as tenants in common, then you will require a will, because as I was telling you guys earlier, the right of survivorship does not exist for tenants in common. So in the event that a person does pass away, so how it works is, just to give you guys a clear picture, when a person takes ownership as joint tenants, everybody on the property owns the property together as 100%. So they all jointly and equally own the property. There's no percentage allocation. So it just says they own it together and jointly. When you buy it as tenants in common, there'll always be a percentage. So they'll say, okay, let's say, for example, 3 friends buy a property together. So it'll just say 1/3, 1/3, 1/3. So there you'll see a percentage division. So when someone passes away, what they will do is they will tell them, okay, your 1/3 is being included in your asset calculation, and then they'll look to your will to see what you have. So once again, if you don't have a will, then it becomes subject to the Succession Law Reform Act, and then in that respect, then you have everything that I told you before, like it becomes first 200,000 spouse, then divided between children, etc. So especially in the tenants in common situation, it's very important overall, but especially people get caught in the tenants in common situation. So I actually had an example. 2 weeks ago, an agent called me and he said, my client's calling, they want to list their property on the market, but their spouse passed away last year. Can I list this property? So the first thing I asked them is, okay, do you know how they took ownership? And he was like, no, I have no idea. So I said, okay, let me go look. So the first thing I did is I checked, and I told him they took it as joint tenants. She has an automatic right to the property. Don't worry, you can go list the house. And you don't need to worry. When we do the closing, I'll do the registration, and then you can put the agreement in the wife's name. When I do the registration, I'll do an application to transfer into her name, known as the application survivorship, and then we can sell the house. But if I told him, if that was a tenant in common situation, you're going to have to go to the courts, and you're going to have to appoint an estate trustee, and you're going to have to do all of that. So you can see how it is actually very tight, and a lot of people don't know that when you're buying a house, you're really planning for your future in case something happens. But a lot of people don't know that. They just go and they buy homes and they don't think about this. So it's very important, and it ties out a lot. So if you guys want more information about this, my law firm is Vetiver Law Professional Corporation. So I'm the lawyer that runs Vetiver Law. Our office is located at McCowan and Milner. So I've just put my phone number and email here. So if you guys have any further questions, please do not hesitate to contact me. I'm always here. I can answer your questions. A lot of you probably have specific questions about wills and you have your specific scenarios. And I'm always happy to incorporate that into your wills or even your home buying process. I can refer other people out to you, etc. And I can definitely do your closings if you're thinking of home purchase as well.
Thank you, Rishani, for a wonderful session. And I believe it was very informative, Rishani, especially for me. I would say that even though I'm working as a medical social worker, every day in my work schedule, I have to deal with some of the concerns and questions with the power of attorney and will. But so far I have some, misinterpretations with will and power of attorney. But today I can literally say that it's all cleared. Thank you.
Thank you.
Thank you so much. And I believe most of my friends and colleagues in MASA also have the same opinion, and I think they will agree with me. And it was really informative and knowledgeable, especially being in a different country, or, rather than from our home country, rest of our life we are going to spend in this new land. So it was very, very informative. Thank you so much for a wonderful
No problem.
session.
Thank you so much for letting me speak.
And I think we can move over to our questions.
Okay.
I have one question from Priya Abraham. Is the lawyer fee is different for wills and power of attorney? And how much is the fee and an estimate? I think she would like to give this information to her patients that he's dealing with.
Okay, yeah, for sure. So so usually, the prices are different for wills and power of attorneys, and it's also different depending on whether they are if it's two, a husband and wife that want to do the exact same will, but they just want to they just want to do the exact same will, but obviously it's gonna be separate, versus somebody who is just doing their own will. And it's also different if they have a lot of specific requirements they want to include versus if it's just general, everything just goes to my kids. So usually when it comes to these type of situations, it's always better to just shoot me an email and tell me about the specific situation, and then I can give you an accurate price quote. And then from there, they're usually very reasonable, but I can give you an accurate price quote from there, and then we can take it from there. So definitely you can shoot me an email about that, and then I can give you a price quote, but they're usually different for wills and power of attorneys. Power of attorneys are usually more general, except if you want to put specific provisions about what they want in their specific power of attorney. So let's say if it's a limited power of attorney or if it's a power of attorney for personal care, but definitely shoot me an email with the specific situation, and then I'm more than happy to be able to give you a price quote and take it from there.
Okay, that was also informative, Rishani, I believe. And there was a question from Sunil, and he asked, what is the scenario if the house owns?
Sorry, what is the scenario of the house?
If we have our own house.
Okay.
So I'm not sure about what exactly that question is.
Okay. Can I talk?
Yeah, sure, Sunil, you can please.
What I'm asking was, what is the scenario if the house owner he's in work permit? If he buys the house owner, the same provision or privileges as a PR or a citizen having. The house owner.
Okay. Okay, so I understand. So you're asking in the event that a person on a regular work permit buys a property, but they're not a PR yet, right?
Yes.
Okay. Okay. So what happens is if you're not yet a permanent resident or a Canadian citizen and you buy a house, what will happen is you'll be subject. So there's a 15% tax called the non-resident speculation tax. So usually if they buy the property, then let's say if they are not married, right, and they buy the property like that, right, then they'll usually have to pay a 15% tax on top of the price of the house. But if they subsequently become a PR, they can get that money back. So usually in 2017, the government introduced the non-resident speculation tax for people who are not residents, they're not permanent residents or citizens, because they wanted to, make more money. But they introduced this tax so that in the event that you are not a PR or you're not married to somebody who is a citizen, then you may be hit with this tax. But keep in mind that because this tax is intended for people who are investors, so if you do subsequently become a permanent resident of Canada, you can get that money back afterwards.
Okay, okay. And what about the will? Will they can put their will in their own, or they can put that will into someone else's names and all?
Yeah, so for the wills are whatever their wishes are, right? So in the event that like they're two separate concepts. So if you buy a house as a like on a work permit, right? The house is still yours. You just paid like a 15% more tax on it, but the house is still yours. So you can definitely include that in your will, saying that like if you want. So usually with wills, what a lot of people do is unless they want to specifically designate a house to a particular person, right? Then what they will do is, so if you want to designate, let's say if you have multiple properties and you want to designate like one house to one child, one house to this investor, one house to this person, then we have to list out every asset that you have. And then we'll say this asset goes to this person. But if your will, you want to give everything to, let's say you want to give everything to two children, right? So let's say you want to give, like if you have 5 properties and you want to give everything to your spouse, and then if something happens to both of you, everything to your 2 children, you don't actually have to list out every asset you own. Because if you do that, then once you sell the property, you have to redo your will, right? Because the will not be current. So a lot of people, if they know that they don't want to, like if they know that everything they have, they want to just give to their family or whoever, then you don't actually need to write out every specific asset. But if you have certain assets that you want to allocate specifically. So a lot of people do. So let's say, for example, if they have 3 children, but they only want to give the house to 2 children, then we have to write out the specific property. And if like some people want to, let's say, give jewelry to one child, let's say they have a boy and a girl and they want to give all their jewelry to one girl, but they want to give their cars to the son, for example, right? Then we have to list out everything and we distribute the assets. But if you just want to say everything goes equally to the children, then you don't have to specifically write everything out.
Okay, thank you. Clear. Yep. Yep.
Thanks, Sunil. And Rishani, there's one more question. I have a list of, should I have a list of all my assets before I prepare a will?
So that depends on how you want your assets to be distributed. So if you want, if you let's say have like a family, like a spouse and a children, and you don't want to separate between them and you want them to have everything jointly and equally, you do not have to, because your assets will change over the years as well. And if you know throughout my lifetime, I just want to give everything to both kids jointly, and I want to give everything to my spouse, and then not my spouse, then my kids jointly, then you do not need to write everything out. If you want to distribute it specifically, let's say, because there's a lot of families that come to me and they say like, you know, one child has done really well in life, but one child, like they have a gambling issue and I just don't trust how they're going to spend it, then we can definitely put restrictions for that child, or we can put property restrictions as well. So we can say, okay, then we'll give everything to the first child or whatever their wishes are. But if you specifically allocate, then we have to write everything out. If you do not specifically allocate, we can keep it general.
Okay, then there's one more. What happened when I have a property and I'm not married? I have kid. Can I write a will to my boyfriend name and my kid?
Okay, so the person is not married. So just repeat that again. The person is not married.
Person is not married, but
okay.
If you have a kid,
okay,
and the will should be both in boyfriend name and the kid's name. That's a question.
Okay, so yeah, so definitely, so it's whatever you wish, right? So if you're not married and you have children, but you want to give to your boyfriend, your kids, you can definitely do that. So the will is whatever your wishes are, right? So if you want to, so even if you, because if you have the house in your sole name, then you're the one choosing what, you don't have to give it to your children first. You can give it to your boyfriend first, and then if it's not to him, your children, or whatever your specific wishes are. And that's why it's really important to have the will, because without the will, so if you do not have a will, in that situation, it will go to the children first, right? So if you have the will, then you can specify, okay, no, I actually want to go to my boyfriend first, and I want my boyfriend to give it to the kids as they please. Then that's why it's important, because the will outlines whatever your specific wishes are.
Thank you. And what is a mirror will?
A mirror will is where like a husband and wife, like let's say, I keep using the example husband and wife, but any people have the identical.
Rishani, sorry, your voice is cutting. Your voice is
So,
breaking. Rishani, hello?
they have to me. Oh, sorry.
Rishani, so sorry, your voice was breaking in between. Could you start from the first?
Of course, of course. Okay, so in that same situation, right? So a mirror will is where one person, let's say there's two people, right? Let's say I'm going to give the example of a husband and wife, right? It's where their wills are identical but reversed. So, for example, on the husband's will, he'll say, if something happens to me, everything goes to my wife. If something happens to the two of us, everything goes to our kids. If something happens to our kids, everything goes to our grandkids. And the wife's will say, if something happens to me, everything goes to our husband. And then if something happens to both of us, everything goes to our kids. If something happens to our kids, everything goes to the grandkids. But the names in all of these are identical. The only difference is in reverse. So that is what's called a mirror. So it's the same but flipped. So usually what happens is when clients come to me and they say we want to do mirror wills for both the husband and wife, usually I offer like a discount or a bundle deal because the wills are identical, but we're just reversing the names. So I'll get down their plan and then I'll offer them a bundle deal if they're doing like a mirror will between spouses. But each one, keep in mind, signs their own will.
Thank you. And is there any other questions? I think it was same regards with mirror will, and the question was, can it apply to anyone?
Yes, 100%. So it doesn't have to be spouses. It can be anyone. So like even if you and your sister or even you and your friend, like if you guys have the same wishes. So as long as the person has the same wishes and they wanted to go to the same people, then it's called a mirror will. So if there's like two siblings and they say, okay, like if it's two sisters and they say, okay, if something happens to me, I'm going to give it to my sister. And if the sister says happens to me, I'm going to give it to my sister. And if something happens to both sisters, they're going to give it to their mom and dad, right? Then you can definitely do that. It doesn't have to be between married spouses. They can be between anyone, as long as mirror wills are when the wills are identical to each other, but just reversed in names. So as long as they do that, it can be anybody.
Thank you. And I guess that's all about questions, and I think we can move on to the conclusion. And let me thank you, Vrishani. It was, as I told, it was very informative and it was very, very beautiful session. And thank you so much for making this time and giving this beautiful information session to Maso. And thanks, Maso, for conducting this very informative session for our friends and colleagues. And also, I would like to thank all supporters of Maso, especially our main supporter and sponsor, Realtor Sunil Sebastian. And thank you all the well-wishers and supporters of Maso again. And before leaving, I would like to wish a very wonderful Onam to all my friends and colleagues. Stay safe and stay well. Thank you all.
No problem. Thank you, Anju, as well, for doing a fantastic job as a moderator. And thank you for Maso once again for allowing me to speak today.
Thank you so much.
Thank you.
Thank you, everybody. Have happy Onam.
Happy Onam, Anju. Happy Onam, everyone.
Happy Onam.